Proceedings on the question will be postponed. Our next item up for consideration is H.R. 162, the Freedom to Petition the Government Act. The clerk will designate the bill.
H.R. 10062, the Freedom to Petition the Government Act, a bill to amend Title 29 of the District of Columbia Official Code to treat meetings held with officials of the federal government which are held in the District of Columbia as activities not constituting doing business in the District of Columbia for purposes of determining whether organizations are required to register with the District of Columbia.
Without objection, the bill shall be considered as read and open for amendment at any point. Without objection, so ordered. The chair recognizes himself to offer an amendment in the nature of a substitute. The clerk will designate the amendment.
An amendment in the nature of a substitute to H.R. 10062 is offered by Mr. Comer of Kentucky.
Without objection, the amendment is considered as read, and the substitute will be considered as original for the text for the purposes of further amendment. I recognize myself for 5 minutes for a statement on the bill and the amendment. I'm happy to support H.R. 162, the Freedom to Petition the Government Act. The bill amends D.C. Code to ensure that nonprofit organizations who are headquartered outside of the District of Columbia are not considered to be doing business within the district if their work is only with the federal government. Requiring nonprofits who are trying to petition their federal government on various issues to register with the district government opens them up to additional and unnecessary liabilities. It also creates a chilling effect for these nonprofits. The D.C. Attorney General has already tried exploiting this situation to investigate nonprofits whose only advocacy is with the federal, not the district government. These nonprofits have not availed themselves to the district, only to the federal offices they are meeting with. H.R. 162 fixes this problem by giving these nonprofit organizations the freedom to petition their government without threat of reprisal from a jurisdiction they would otherwise not be subject to. The fix is a win for free speech and for the various organizations that advocate in front of federal officials. I thank Representative Biggs for introducing this important legislation, and I encourage my colleagues to support it. I now yield to the ranking member for his opening statement.
Mr. Chairman, thank you very much. We were doing so well there in bill after bill. We had real bipartisan unity. Now I'm afraid I've got to oppose this one, which I can't say I fully understand yet, but it clearly looks like one more attempt to interfere in the local affairs of the people of the District of Columbia, which has been a favorite political target of some in the majority of this Congress. The majority's worked to overturn a variety of local D.C. laws and to put the home rule government, representing more than 700,000 tax-paying American citizens, in a straitjacket. And there are obviously some people who prefer to govern the District of Columbia directly as a colonial population rather than to grant its statehood petition. But let's look at what this so-called Freedom to Petition the Government Act does. The title suggests nicely that the bill's about protecting the rights to free speech, association, petition, and privacy. Of course, nobody's right to petition the government or to engage in free speech or association has been violated in any way, or at least nobody has explained how it has been. Businesses, both not-for-profit and for-profit businesses, have to register to do business in any state or in the District of Columbia where they do business, and that is not a violation of their First Amendment rights. In fact, the Supreme Court has repeatedly held that it's perfectly okay for a state or for Washington, D.C. to require businesses that are doing business there to register, even if they're lawfully incorporated in a different jurisdiction. So I'm not quite sure why this is getting blown up into a big First Amendment question. It might have something to do with an investigation that has reportedly been launched by the Attorney General for the District of Columbia into the business dealings of Leonard Leo and certain allied not-for-profit organizations. There was an article in Politico which said, what happens when an Attorney General dares to investigate Leonard Leo's network? And the article began by saying, allies of Leonard Leo have mounted a months-long offensive against the man investigating the judicial activist network. And I think that may explain what this bill is about, but I would invite the legislative sponsors to really explain what's going on here. The District of Columbia, of course, is not unique in requiring business organizations, whether for-profit or not for-profit, to register when they're doing business in the jurisdiction. It's very hard to see why there should be some kind of exception carved out here. Anybody who does business in any state or in the District of Columbia should be subject to the laws of that state. And if any state or the District of Columbia is violating anybody's right to petition government or right to engage in First Amendment activity, then that should be struck down. But this looks like a little bit of a wolf in sheep's clothing, and so I'm going to oppose it and would invite you, Mr. Chairman, or the sponsor to explain what this is really all about and what's the genesis of this legislation. I yield back. Thanks.
Thank you. Do any other members wish to be heard? Chair recognizes Mr. Biggs.
Thanks, Mr. Chairman, and I appreciate this markup and for consideration of my bill, the Freedom to Petition the Government Act. Federal government officials, officials at the White House, at federal agencies, members of Congress, our staff, and others are constantly meeting with nonprofits to discuss their work. So let's clarify that. These are nonprofits. They're not just any corporate or sole proprietor. These are nonprofit organizations. And they're meeting solely with federal officials on federal property. That's what the bill says. I don't know why that's confusing to you. Anyway, we meet with them constantly. They want to talk about the impact of federal government action on it. These nonprofits must comply with existing federal law to maintain nonprofit status. Currently, District of Columbia law requires that a nonprofit not headquartered within the district must register with the district to hold meetings with members of Congress or other federal officials. That's what their law requires. D.C. Code requires a nonprofit to register when it is doing business within the district, even if that business has nothing to do with D.C. That's like if they're going to meet with the representatives of the federal government on federal government property, they include that in there, which is why we actually tried to clarify that with the ANS, with negotiations with the D.C. government. So, this bill opens this law opens these nonprofits to unnecessary, frivolous, and partisan investigation from the D.C. Attorney General, and that creates additional liabilities and a clear chilling effect for nonprofits that want to engage with the federal government. And by the way, we're not interfering with D.C. law. D.C. law is interfering with Americans' right to meet with their federal government officials. The Freedom to Petition the Government Act amends the D.C. Code to stop this practice. Nonprofits should be able to travel to the seat of our nation's capital to advocate, inquire, and engage with the federal government free of retribution from partisan efforts to stop such outreach. It explicitly states within the D.C. Code that nonprofits not headquartered in the district do not need to register with the district. That's what this bill does. This protects nonprofits from opening themselves up to overzealous investigations in a jurisdiction that would otherwise have no claim over these nonprofits' actions, which is very distinct from what the ranking member was describing. This provides these organizations the freedom to engage with federal officials, and I urge my colleagues to support this common sense legislation. And I would point out we have acceded to some of the requests of the D.C. officials, and that's reflected in the ANS. And so I'm not representing in any way that they support this. I'm just saying that we tried to meet them where they had concerns, and that's what the ANS is doing. And so I urge passage of this, and I yield back.
Will the gentleman yield for one question?
Happily.
Do you understand that the District of Columbia has the exact same law that exists in your state, in every other state, with respect to the requirement to register if you're doing business in the state? And that language doesn't mention Congress or lobbying anybody. It simply says that if you are a corporation from another state or a foreign corporation, you're doing business there, you've got to register. And that exists in Arizona.
Yeah, so I will respond and say this. Here's the deal. The federal government, the seat of federal government is not in Arizona. It's not in Maryland is not, it's here. And these non-government operations, they're coming here to meet, as we say in the bill, on federal property, to meet with federal officials.
If that's all they're doing,
That's what it says right there. So they would have no.
but they're not doing business. No, but in other words, they're not.
They are, but the bill, if you read the law,
Yeah.
their current law,
Yeah,
it does not provide that exception.
it doesn't need an exception if they're not.
Sure, it does, because that's what they're investigating. They chose to investigate Mr. Leo. Why?
If he has offices,
He did not have offices here.
He has no not-for-profit.
He had a
corporations.
post office box that he checked periodically. That's what you're saying is business.
Okay, well then I think that goes to the question of whether or not he's doing business.
That's
here,
correct.
right? Yeah.
And that's the point we're trying to clarify. And I agree that, I'm glad you agree that that was the question in the Leo case. We're clarifying it now.
But why
Go
does
back.
that? Can you just explain why? Again, I'm just trying to find out because this is the first I'm learning of this whole thing. Why do we need to intervene to pass a federal law about this? If they're not doing business in the District of Columbia, it shouldn't be an issue, right?
That is correct. It shouldn't be, but it has proven to be. And so you would say your position would be, well, Leo was doing business, and my position would be he wasn't doing
Well,
business.
I have no idea
And the
whether or
point-
not he was.
Well,
Is there a case on that? Is there a case that's been brought on it within the District of Columbia?
They brought action against him. So the point I'm trying to make to you is, basically you're kind of agreeing with me, I think, but you.
I agree. If he's not doing business in the District of Columbia,
And I'm trying to provide clarity to saying, look, if you're coming in here and you want to meet with us, and you're meeting on federal property, then why would DC even consider it has jurisdiction? And in the correspondence that we've had with the DC Attorney General, he was adamant that they did at first. I think he's kind of walked back away from that. That's one of the reasons I think it has to be clarified.
okay.
Do any other members wish to be heard?
Mr. Chairman?
Ms. Norton first?
Oh, I'm sorry.
Ms. Norton, you're recognized.
I would like to start by asking unanimous consent to enter into the record a letter from D.C. Council Chairman Phil Mendelson opposing this bill.
Without objection, so ordered.
I strongly oppose this bill, which violates the District of Columbia's right to self-government. This bill amends a D.C. law to exempt certain business organizations doing business in D.C. from registering with D.C., even though each state requires business organizations, whether for-profit or non-profit, doing business in that state to register there. The intent of this bill is to reduce D.C.'s authority to apply its law to nonprofits that are formed under the laws of another jurisdiction doing business in D.C. Why would this committee amend D.C.'s business registration law, which is like the business registration law of each state? Contrary to Republicans' claims, this bill is not about the First Amendment, which, of course, no enforceable law can violate. There are two reasons for this bill. First, this committee has abused its undemocratic authority over D.C. more this Congress than in any time in at least 2 decades. This is the 8th bill this committee has marked up or brought directly to the floor to repeal or amend D.C. laws or regulations. These bills have ranged from stripping D.C. of its authority to increase criminal penalties to repealing a D.C. environmental regulation to amending D.C. public sector employment laws. Second, the D.C. Attorney General apparently did something this committee considers radical. He enforced D.C.'s Nonprofit Corporation Act. The D.C. Attorney General reportedly is investigating nonprofits affiliated with a conservative legal activist for misusing charitable funds for the activist's personal benefit. This bill is step 2 in this committee's response to the D.C. Attorney General's reported investigation. Step 1 occurred last year when this committee launched an investigation of the D.C. Attorney General's reported investigation. My Republican colleagues are correct that D.C. has the constitutional authority to legislate on D.C. matters, but they are wrong that Congress has a constitutional duty to do so. Legislation on D.C. matters is a choice. As the Supreme Court held in 1953, and I quote, "There is no constitutional barrier to the delegation by Congress to the District of Columbia of full legislative power," end quote. The Revolutionary War was fought to give consent to the government and end taxation without representation. Yet D.C. residents cannot consent to any action taken by Congress, whether on national or local D.C. matters, and pay full federal taxes. Indeed, D.C. pays more federal taxes per capita than any state and more total federal taxes than 19 states. If House Republicans cared about democratic principles, they would bring my D.C. statehood bill, which gives D.C. residents voting representation in Congress and full local self-government to the floor. Congress has the constitutional authority to admit the state of Washington, D.C. It simply lacks the will to do so. I urge my colleagues to oppose this bill.
Do any other members wish to be heard?
Mr. Chairman.
Chair recognizes Mr. Cloud.
I'd yield my time to Mr. Biggs.
Thank you, Mr. Chairman, and thank you for yielding, Mr. Cloud. So let's talk about what was just read from one member of the D.C. Council. The council person, I don't know who it was, mentioned jurisdictions of other states, that other states require entities that are doing business in those states to register. We agree with that. That's what happens. D.C. does that. We're not taking that away. But one thing that they didn't mention in there is that we're talking about the federal government. And we're talking about where those meetings taking place, what are these NGOs coming in to do, and they are dealing with federal officers. And when you, I want to read something here that I find intriguing from a letter from the D.C. Attorney General. This is his defense of this. Out-of-state nonprofits that choose to register and do business in the district enjoy a number of benefits by virtue of that choice, including unparalleled proximity to key players and decision-makers across the federal government, such as members of Congress and their staff. But here's the deal. If you are a foreign non-government organization or a not-for-profit, and you're coming in and you want to visit with us, under the D.C. Code, that could be interpreted to be conducting business. And if that's the case, then you are chilling free speech, and you are chilling NGOs, not-for-profits coming in. That's the problem. I mean, because he's requiring registering.
Will the gentleman yield for a question?
Yeah.
Well, has that happened? In other words, is that I was not aware that the District of Columbia was interceding with not-for-profit corporations that just come to Washington for the purposes of meeting a member of Congress and saying you've got to register before you do that.
So he's claimed that authority essentially in the Leo case. So if you look at the Leo case, which even Politico, which broke that story, admits there was nothing there. It was rumor and innuendo, but he chose to investigate that, even though it looks like Mr. Leo and whatever his nonprofits are, and I don't know anything about his case, but they all seem to be outside, located outside, and actually perhaps even based in Arlington. And he's chosen to investigate that. He's not defended that, saying, yeah, I think they're doing business here.
Can I just ask you two other questions about the scope of your bill, just to understand? I'm really trying to understand this. So, but one is the not-for-profit corporations that are, say, organized in Arizona or in Maryland may have to also go and talk to state legislatures as well. Should they be exempt from having to register in those states doing business? Why is it not written to deal with people who are going to the state capitals, in Annapolis or Albany or whatever?
So I think that becomes a state issue, and D.C. is under the federal control of Congress. So let me just clarify additionally.
Yeah.
If I am, because I used to work with nonprofits in Phoenix. If we have to go to, let's say Dallas or something like that, we don't have to register in Dallas for me to go in and stop in and meet with them.
Right.
That's what we're saying.
But I'm not aware but is that the rule here? Because I hadn't heard any complaints about that happening.
Well, I think you should. I'm sure you're privy to the responses that the local AG gave to the letters written by Mr. Comer and Mr. Jordan, the two chairmen, and that colloquy through verse that they gave, through prose that they gave. But it looks to me like he is making the assertion that, that he could do that if they chose. And so that's why I think the bill's important. And by the way, if you don't think that's happening, then this bill will do no harm either. But the point is, if it is happening, which I would suggest to you, this Attorney General, at least in one case, potentially did that, then maybe we should intercede.
And if I could just ask one other question about the dimensions of the proposal. It says this applies to all entities, presumably under 501c, so that means 501c3, C4, C6, or is it just C3s?
You're talking about the ANS? You're talking about ANS.
Yeah, it looks like
it looks to me like it's all 501c.
Okay, so have we looked at the implications of that? If there's a C4, a C6,
if they're doing business, if they're not coming in, if they're actually conducting business here, I don't know that this statute is going to provide that exemption for them. That's
I guess in that it's the grammar of it that puzzles me when you say holding a meeting with a member of Congress. Does this only apply to those 501c organizations that are holding a meeting? Or is that sufficient to make them exempt to go and hold one meeting, even if they're doing other business in the District of Columbia?
Well, that's one of the reasons that we've limited it. It's because if they're conducting business here, we get it, we understand. But in reality, if they're trying to exercise fundamental rights, then the D.C. AG should not be investigating, prosecute, whatever you choose.
I would agree with this, and I would get on this if you just put the word only in there, only holding a meeting with a member of Congress, because that would be ridiculous.
Well, what about if you go to lunch with a member of Congress?
Only holding a meeting or having lunch with a member of Congress. I mean, I think having lunch would incorporate it. But what I don't want this to become suddenly like an escape hatch for people who are actually doing business here and saying, well, we did a meeting with a member of Congress, so now even though everybody would acknowledge we're doing business, we're suddenly exempt from the laws.
I think you're straining at a gnat.
I really don't think I am. I think I'm going right to the heart of it.
I don't think you are going to the heart of it. I think you're saying, because I think as the council member said, gee, this whole body's been out to get D.C. We're not out to get D.C. What I'm trying to do is protect, and we're trying to carve out protections for the D.C. government as well as for citizens to come petition the government.
But is holding a meeting enough to exempt someone from D.C. law with respect to registration, even if everybody would concede that they are also engaging in business?
I don't think so.
Okay.
I don't think so. I mean,
I think we got to rework the language.
So to that end, Mr. Chairman, I would ask a unanimous request that the two letters written by yourself and Chairman Jordan, as well as the two responses from the Attorney General from the District of Columbia, be admitted into the record.
Without objection.
And also, I would also request that Chapter 4, of the District of Columbia Code be admitted into the record as well.
Without objection, so ordered. Conclude. Chair recognizes Mr. Goldman.
Thank you. I'm going to follow up on the ranking member's questions because I do want to get down to the rub, because the appearance here is that the DC AG began an investigation into Leonard Leo and all of his various nonprofits because there were allegations that Mr. Leo was misusing the nonprofits for his personal gain. And I assume, Mr. Biggs, you agree that that is, if true, that's a valid basis for an investigation. Is that right?
By the appropriate authority, yeah.
Okay. So then you're saying that the DC Attorney General is not the appropriate authority because the DC Attorney General does not have jurisdiction or should not have jurisdiction if the nonprofit that they are investigating only has a drop box in the District of Columbia. Is that right?
Well, I mean, you've asked a compound question and asked me, is that right? What I would suggest to you is there is, I think that's probably right.
All right, well, let me ask it this way then. Fine. Do you agree, does this bill, and I'm going to get to what Mr. Raskin was getting at here, does this bill, in your view, say that if a 501c organization has a meeting with the federal government or Congress, then there is no jurisdiction for the District of Columbia's Attorney General to conduct an investigation into that 501c organization, regardless of all of the other activity that 501c is doing?
I would disagree with your interpretation. We've defined, quite frankly, I think a minimal carve-out ultimately saying and intimating, this is not business. This is not doing business in D.C.
So you're saying that if you have a meeting or if you are addressing the federal government in some fashion, Congress, some other executive branch agency, that does not qualify as jurisdiction. That's what this bill does. It says that if that is the conduct you are doing in D.C., then that does not qualify, that does not satisfy D.C.'s jurisdiction to investigate.
Yeah, I'm looking and I'm comparing it to 29105.05 of the D.C. Code. And we're saying, if you're here, and you notice we just said holding meetings with members of Congress, that doesn't constitute under 29105.05 the activity for which you should be required to register with the District of Columbia.
Okay, what happens if a 501c has a meeting with another 501c that is in D.C., headquartered in D.C., perhaps gives money to that other 501c in D.C., and then separately goes and has a meeting with Mr. Biggs about something else? Does D.C. have jurisdiction over that 501c?
Well, let's. It's really that's a baffling question, and you truly have a dizzying interpretation of this. I'll tell you. What we've done is we've carved out a spot, and we've said, if you're going there for meetings with members of Congress, their staff, if you're meeting on federal property, you don't fall within the jurisdiction. And what you're saying is, if they come in here and they're actually conducting business, other business, well, that's a different animal, isn't it? Do you think it's a different animal?
I don't think this bill makes it clear. I think this bill allows for stripping jurisdiction.
And
the way it's written, it allows for stripping jurisdiction of any organization, any 501c organization that has a meeting with Congress. regardless of whether they're doing other business in D.C. And that's why Mr. Raskin's suggestion that you say we'll strip jurisdiction if your only business in D.C. is meeting with the federal government, that's one thing, but that's not what this bill says. So if you want to clarify that, I will happily support that.
Well,
but
so
the problem is this is...
Would the gentleman yield?
No, one minute. I'm just finishing up my time. I'm happy to continue. But the problem with this bill is what you are doing, and what is very clear that you're doing based on Chairman Comer and Chairman Jordan's letters, is you are trying to interfere and intervene in an ongoing investigation by the D.C. Attorney General into the Republicans' biggest benefactor. And when we talk about the weaponization of government, the idea that the federal government would try to interfere and intervene and supersede an investigation based on very vague language, when we all know that Mr. Leo does a lot more than meet with federal government officials and that all of his organizations do a lot more business in Washington than meet with Congress, you are trying to backdoor in a way to strip jurisdiction over Leonard Leo by the D.C. Attorney General by including very vague language that can be interpreted to say, as long as you're meeting with Congress, you have one meeting. If you have 100 meetings with other people, it doesn't matter. You're exempt from jurisdiction. And that's the problem with this bill. And I yield back.
Chair recognizes Ms. Boebert.
I yield to my colleague from Arizona, Andy Biggs.
I thank the gentlelady for yielding. I find myself, I felt we were having some kind of rational colloquy there until we kind of left the universe here, and now we're wandering in space. I'm going to try to bring us back down and say, I happen to have the code here. I encourage you to read the code, because the way we've crafted this language is if you're here for a fly-in, doggone it, then the DCAG doesn't have jurisdiction over you, okay? That's the point. Well, you guys are trying to come up with every nefarious thing and every rationale you can possibly come up with and say, well, gee, we got to expand this language. This is a very simple, straightforward language. It says, if you're having a meeting, that's not conducting business in D.C. But the ordinance that defines all kinds of other stuff, that's business. We didn't touch that other stuff. We touched if you're coming in for a fly-in to meet with Moskowitz or anybody, particularly Moskowitz. In particular, I was thinking about that. You're protected from investigation hassle from the DCAG. You don't have to register with him. But if you're conducting business, we haven't touched you. That's what's baffling to me.
Will the gentleman yield? So,
Well, you have to ask the gentlelady. It's her time.
thank you, Ms. Boebert. You're avoiding the question, Mr. Biggs, and it seems intentional. And the reason why we are skeptical over here is that Mr. Leo has declared he's not cooperating with the investigation. Chairman Comer and Chairman Jordan have tried to intervene and interfere in this investigation. And now we have a jurisdiction-stripping bill in the Oversight Committee that is clearly directly related to this investigation. So please spare me the outrage that we are skeptical given the timeline here. But the question I have for you is, as you interpret this bill, if you're saying a fly-in is exempt from jurisdiction, you don't have to register. If somebody does a fly-in and also satisfies one of those other elements of the code that would establish doing business in D.C., does that organization still have to register because of that other conduct, separate and apart from the fly-in?
That's the way I interpret it. That's why I said if you read the ordinance, you'll get a pretty good idea how they're attacking registration for business activities. We're simply saying, you're here, you're having a meeting with members of Congress. That's not a business activity. Now, if you go out and you start conducting other business, then there's nothing in here that protects you from that jurisdiction. We're not stripping jurisdiction. We are trying to refine and define and protect fundamental civil rights to speak out and meet with and petition your government. That's what we're trying to protect.
And by the way, if
And by the way, you know, I'm not outraged. I'm happy to have the colloquy. I think it's fine. It's good. But if you're saying that you don't trust me, that's fine too. But for all of you guys who are on the other side now saying, oh gosh, we have to have bipartisanship, we have to have trust, I'm telling you what I think this bill does. I'm telling you why we did it. And you are approaching it with this massive amount of skepticism, and that's fine because we have a history of skepticism, particularly in this committee. But if we're ever going to get past it, at some point you got to say, well, this really doesn't do everything we said. We could create every hypothetical in the world because we're a bunch of stinking lawyers who went to law school. We spend all of our time getting hypotheticals all the time. But the bottom line is we're saying, look, you're coming in, you're meeting with a member of Congress for purposes of the D.C. Code, which we otherwise are holding harmless. That doesn't constitute doing business in the district. That's the point.
Will the gentlelady yield?
The gentlelady needs to yield.
I appreciate that. The skepticism is because laws are interpreted and they are implemented. And so you have to consider hypotheticals to anticipate how they will be interpreted and implemented. And the concern I have here is if what this bill is actually intending to do what you say it is, A, it's not written clearly, and B, it would not accomplish the goals of Chairman Comer and Chairman Jordan because it would almost certainly not strip jurisdiction from the D.C. Attorney General against Leonard Leo.
Reclaiming Boebert's time, Ms. Boebert's time, I'll say, and you've just undercut your whole stinking argument where you've developed your skepticism because I wouldn't protect Leonard Leo with this. What we're doing is we're protecting the people who are flying in from any kind of overreach on the part of the D.C. AG. That's the point.
Is there an example that you can cite of that happening?
Well, then if you can't find an example, then why do you care? Because then it's no harm, no foul.
Well, I'm asking you, is there an actual example of somebody, of the D.C. Attorney General doing an investigation of a 501c that's only business and only contact with Washington, D.C. is to fly in to meet with a member of Congress?
I would refer you to the responses of the D.C. AG to the letters from Mr. Comer, or Chairman Comer and Chairman Jordan, where, at least the way I interpret it, he's implying that he has that authority.
Okay.
Well, it is weird.
Ms. Boebert's time's expired. Mr. Moskowitz.
Thank you, Mr. Chairman. First of all, I think this is healthy, right, having a discussion about a bill. I think that's the whole point of workshopping things. So just to go back to Ranking Member Raskin's question, which I think you're answering. I think we just want it to be just a tiny bit clearer. Because obviously legislative intent is part of the record. So your intent, and you believe the language, is not an exemption if you're doing business in D.C.
That's the way. That's correct.
Okay, yeah, that's what we want to hear. It's not an exemption, right? So coming in and meeting with a member, right, if you do business in D.C. is not an exemption.
That's correct. Because you would still be subject to the code because the only thing that would not be doing business. So we're just basically saying you're not doing business pursuant to the D.C. code if you're meeting with members of Congress or the staff.
Perfect. So I'll say it in reverse. If you don't do business in D.C., coming and meeting with a member of Congress doesn't give D.C. jurisdiction.
Correct.
Okay.
If the gentleman would yield. Thank you very much. I actually think we've made tremendous progress here because I think substantively we agree. I think we're converging around the idea that a not-for-profit that's incorporated elsewhere doesn't, quote, do business in the District of Columbia simply because there's a meeting with a member of Congress or, as you've said, another federal representative or employee. If you come in to meet with the IRS, you come in to meet with the Department of State, that doesn't turn you into someone doing business in the District of Columbia. I think that the language is a bit inartful, so it could be open to different available interpretations, but, I would be prepared to support that idea if we could, work that language out more specifically, despite the fact that it's not clear that it's necessary, but I think we all would agree to that.
So I think If you would yield, Mr. Moskowitz. So the language we have here was developed in consultation with the mayor's office. That's how we ended up with that specific, which is, I can't see it without my glasses. 11. It's bracketed 11. So that language itself was developed in consultation with the mayor's office, which is why it says what it says.
I mean, given the legislative history that's involved in this conversation, I really have no particular problem with it. I don't quite see its necessity, but there's a lot of stuff around here that's not necessary.
Yeah.
You know, I wouldn't fight it. I don't know that I would support it because I don't see it as being necessary, but I like your clarifying explanation that it's just the activity of holding a meeting itself does not confer the status of doing business in the District of Columbia.
That's correct.
All right, and I yield back. Thank you, Mr. Moskowitz.
Mr. Moskowitz, may I yield? I want to just clarify that this is part of the reason of the skepticism, is that if that is the intent of the bill, it is a useless bill. It is redundant, it is unnecessary, because I don't think anyone can cite a particular case or investigation that hinges on jurisdiction based solely on one fly-in or one meeting with Congress or one meeting with the federal government. And that's where the skepticism becomes, is that it's unusual to write a law to address something that is not a problem, where a problem doesn't exist. And if you are making clear that jurisdiction is not conferred based on only a meeting with Congress or the federal government, I don't have objection to that. If what this bill says, and this is where it's not clear, that if you have a meeting with Congress or the federal government, then it exempts you from jurisdiction, that would mean that entities that do lots of business in Washington, D.C., and also have a meeting in Congress no longer are subject to the jurisdiction of Washington, D.C. And that obviously would be a very problematic bill. So I urge you to correct and clarify that, Mr. Biggs, and I don't think you will get a lot of objection because it's not clear in the bill.
I can be loud without the microphone. You mentioned something about the mayor's office. Can you expand about that? Did you work with the mayor's office?
Our staff did, yes, that's correct.
Okay. Giving you the rest.
Okay, thanks. The statement was made that we don't normally get ahead of issues. So I'd say word number one, we're getting ahead of issues. Number two, who around here has been around here a little while and hasn't seen superfluous bills come to the floor? Now, I'm not saying this bill's superfluous. I'm just saying that's not a reason not to support the bill. Third thing is, I'll give you an example, because we are amending the code section, which is entitled "Activities Not Constituting Doing Business," which is why it's worded or framed the way it is. It may not be artful necessarily, but that's why I think it came up the way it was. But let me give you an example one. It isn't, if solely maintaining accounts in financial institutions, you're not doing business here. Does anybody find issue with that was superfluous? And that's the point I'm trying to make ultimately is, I think it is necessary, and it is clarifying. And I think, and I would offer this to the ranking member, if at the conclusion of the day, if this is moving forward, I'm happy to sit down and craft more artful language, if that's something that the ranking member would like to do. So with that, I'll yield back to Mr. Moskowitz.
Mr. Moskowitz's time has expired. Any other members seek recognition? Mr. Mfume. Oh, yeah, Mr. Mfume.
Thank you, Mr. Chairman. I'm going to cast all caution to the wind and extend this colloquy just a little longer, but I'd like to extend it. I'd like to extend it by yielding my time to my Marylander on this committee, my colleague who is the ranking member, so that he might, in fact, have the last word to conclude his position. I yield to Mr. Raskin.
Okay. Thank you very much, Mr. Mfume, for that. And I really have nothing to add. I appreciate the comments of the gentleman from Arizona. I think that we've arrived at substantive agreement on this. I think we probably differ only as to the necessity of passing it at this point. But I'm happy to engage in further discussion with you about that, and I'm happy to yield back to the distinguished gentleman from Baltimore.
Thank you very much, Mr. Chairman. All's well that ends well. I yield.
All right. Any other members seek recognition? Seeing none, the question is now on the amendment in the nature of a substitute. All those in favor signify by saying aye. Aye. All those opposed signify by saying no. In the opinion of the chair, the ayes have it. The amendment is agreed to. Now the question is on favorably reporting H.R. 162 as amended. All those in favor signify by saying aye. Aye. All those opposed signify by saying no.
Mr. Chairman,
Chair recognizes
request a recorded vote, please.
a recorded vote is ordered by Mr. Biggs from Arizona. As previously announced, further proceedings on the question will be postponed.